getting WrestleMania next year. But off the top, we are going to be talking about a significant development in the Janel Grant case that was released this morning. Brandon Thurston here has a exclusive statement from the parties, and I'm just going to read from Brandon's story that you can read in full up at postwrestling.com, that a new filing was submitted on Wednesday revealing that WWE's former executive, John Laurinaitis, has been removed as a defendant in the lawsuit filed by former WWE employee Janel Grant, WWE and its former CEO and chairman, Vince McMahon, as well, defendant in this case with WWE. And the statement that they have provided reads as follows, quote, John Laurinaitis has agreed to cooperate and provide evidence in Janel Grant's lawsuit against Vince McMahon and WWE. His agreement to a confidential settlement is a pivotal next step toward holding McMahon and WWE accountable and bringing justice to Ms. Grant after years of sexual abuse and trafficking. Mr. Laurinaitis looks forward to moving on with his life. We cannot provide any additional details at this time. And this was a joint statement. We will note that Ed Brennan, the legal representation for John Laurinaitis, did confirm to Brandon as well. So this is a pretty significant event, and this is not the first time that John Laurinaitis has switched allegiances in this case. And I think that is going to draw a lot of attention here, that this was somebody that was named as a defendant, and then it appeared was going to be working with Grant's side, and then got fully behind Vince McMahon in this case around a year ago this time, and now is reaching this settlement to have his role as a defendant removed in order to present evidence to Janel Grant's team.
Yeah. So, and what's alleged against John Laurinaitis in this lawsuit is very serious. Grant alleges that he participated in sexual assault against him, as well as Vince McMahon. Now, it's important to note that there appears to be some sort of agreement between the two sides here, and he has been removed with prejudice. With prejudice means that Grant can't bring these claims back. It suggests that there's been a pretty strong agreement here, and what they say is that Laurinaitis has agreed to cooperate with evidence, and evidence is becoming important in these legal issues surrounding Janel Grant, because we know that we're waiting now. By June 13th, the defendants who remain, which are WWE and Vince McMahon, are expected to refile their motions to compel arbitration to try to get this out of public court and into a private process where there would not be public filings, and the conditions might favor the defendants. And we expect those again by June 13th. However, the judge did rule that Janel Grant is allowed to request discovery related to this arbitration issue itself. The arbitration issue is that there's an arbitration clause that's part of the $3 million NDA that Janel Grant and Vince McMahon signed. Will it be enforced or not is the big legal question. So she's going to be allowed to request evidence. We'll see how that unfolds. She has also prevailed in Dr. Carlin Kolker's motion to dismiss their separate state lawsuit. So she's going to be able to get evidence in that case as well. Maybe that will be relevant too.
Yeah, there's a few factors that come up from this. One of which is that when we saw the initial complaint and further with the amended complaint has always been the text that Vince had sent that were very damning in terms of Vince McMahon's characterization in all of this. And we have heard like the talk of, well, if you saw these full messages in context with what was being said back and forth, this would I'm not going to say paint Vince McMahon in a stronger light, but everything you have heard is that, well, Vince McMahon did not hold on to these text messages. Those do not exist. And a big question in all of this is, well, what text would exist on the John Laurinaitis side that he was in correspondence with Vince McMahon and Janel Grant as well? But further to that, random thought is just how you assess John Laurinaitis' credibility in this whole entire thing. Like this is one where like you look for like a plausible, like this is John Laurinaitis making sure that he is taking care of John Laurinaitis, and it has been very transparent over this period since January of 2024 that he is willing to align himself with the party that is going to get him off the stage of this entire civil case, and he has apparently been able to do so. But I think it also comes with like questions about, you know, his character and all of this as well, in terms of being a credible witness.
And the timeline is, so this lawsuit was filed in January 2024. Then a few days later, John Laurinaitis, through his attorney, gave the statement to Vice News saying that he's a victim too of Vince McMahon. So it looked like he would be on Grant's side going forward. But then just a few months later, in May 2024, he came out with another statement saying he corroborates Vince McMahon's, denials, and that these are unfounded allegations. And since then, until today, we've seen things like Vince McMahon file motions to compel arbitration and make other legal filings where the Laurinaitis side just sort of made much simpler filings, basically to say, yeah, I'm on board with what the defendants are saying here. So maybe
Which, let's just say the timeline, as recently as February 21st is when the defendants, including John Laurinaitis, had filed these motions to oppose Janel Grant's amended complaint. So, I mean, this is a development that has occurred in, you know, at most in the last 3 months, this switch for Laurinaitis.
I think it's worth noting that we saw like full filings from WWE on motions to compel, saw full filings from McMahon on motions to compel, and what Laurinaitis filed, I believe, were called joinders. So it's just a very simple filing,
like a
as
sign
if to
off.
say, yeah, I'm on board with what they're saying. Yeah.
So, I mean, it is left to speculation about like what kind of deal Laurinaitis was able to craft for himself, the key being that he is no longer a defendant in this case, and what evidence he brings forth. But again, as we're going to end every discussion about this case, it's Judge Sarah Russell that has the ultimate, she will dictate where this case goes, regardless of who is on Janel Grant's side or not. But this does, in theory, present a lot of possible evidence that Janel Grant's team is now privy to through John Laurinaitis, and that he is on this side of the fence against the defendants.
Right. She's going to be able to request evidence. There very well may be disputes about what evidence she's allowed to get, and in terms of the defendants trying to minimize what kind of evidence she can obtain. We should mention too, there's this shareholder lawsuit, a total separate action, one of Vince McMahon's many legal actions, the shareholder lawsuit, which now does not involve WWE as a defendant, but it is against Vince McMahon and various other members of the board at the time of the TKO merger. Anyway, what's happening in that case is the plaintiffs, who are shareholders, are trying to get any communications records from Vince McMahon that are related to the sexual misconduct allegations, and he's trying to limit the sexual misconduct allegations communications records to be only from between himself and the board members who were helping make the decision about whether TKO, who WWE is going to merge with. Unclear if that evidence could help Grant's case, but it seems possible.
Yeah, and you had written about the fact that Vince McMahon is accusing the plaintiffs of harassing and pressuring him in order to move into discovery and give up more than you're in, which I'm sure is not too uncommon, is defining what you would merit as reasonable for the discovery process. That, you know, there is going to be that gray area of, obviously, the plaintiff side, they want as much information as possible, but where do you draw the line here of where this is relevant to a shareholder lawsuit? It's this tangled web that ultimately that there is, you know, the courts have to make this decision of like what is prudent to this specific case, and if it oversteps the reach that discovery should be the forum for.
And if I can try to put a fine point on what the disagreement is here, this is not a lawsuit in specific about the misconduct allegations. This is a lawsuit about allegedly Vince McMahon predetermining the process that led to him making a deal with his friend Ari Emanuel to merge UFC Endeavor's asset and WWE. That's what the plaintiffs allege, and that's what Vince is really pointing to say, you don't need communications with, for example, my family members that I may have had about the misconduct allegations. All you need are communications about the misconduct allegations included with members of the board who are also involved in making the decision about the merger. The plaintiffs say that, no, we want all of this communications related to the misconduct allegations because it's important for us to understand what your thought process, what your motives were going into the merger and acquisition process.
Yeah, such as Endeavor and Ari Emanuel stating as much in the CNBC interview right after the merger was announced, that it was necessary for Vince McMahon to be part of this merger process. And if that swayed Vince McMahon in terms of finding a partner that was going to allow him to make that transition to the new company, as opposed to maybe one that is more valuable on paper, but would not have a seat for a Vince McMahon, that they would feel he is a detriment to this company's plan to move forward and attach to these allegations.
Right. And the plaintiffs would say that there was no other company that was going to allow Vince to have as prominent a role as he had in TKO for several months anyway before he resigned.